In this video, I'm going to discuss your right to the presumption of innocence, which is part of the Canadian Charter of Rights and Freedoms, and how this charter right may result in charges against you to be withdrawn. Now, the Charter of Rights and Freedoms is an incredibly important document. It's effectively a rule book, rules that the police and the courts must follow as they prosecute charges against you. And if the rules are not followed, then it may be possible to get your charges withdrawn. And I have a whole video where I've dedicated to speaking about the charter and how it works and its impact on your life as you're facing a criminal charge. And I suggest you watch that. But in this video, let's turn to the topic of the presumption of innocence, which this right it's probably the most important charter right in our legal system. This right presumes that you're innocent, and it's covered in section 11D of the charter, and I'll read it here where it says, any person charged with an offense has the right to be presumed innocent until proven guilty, according to law, in a fair and public hearing by an independent and impartial tribunal. Now, let's talk about your right to be presumed innocent in the context of talking to police. The mistake that many people make is they believe that by speaking to the police when arrested that they can talk their way out of it. Or it's even more common that people believe if they refuse to answer questions that the police ask them, that it makes them look guilty. The most important thing to understand is that it's never, ever up to you or the accused to prove that you're innocent. It's up to the government to prove that you're guilty beyond a reasonable doubt. And I could speak at great length about all the nuances about what this means, but it's best to look at it this way. When the police have arrested you, they believe you've committed a crime. So when asking questions, they may appear to have your best interest in mind, but you know what? They don't. The police have a job. They're looking for evidence to help reinforce their belief that you committed a crime. They may act very friendly and polite, and in fact, that may be sincere, but they're also trying to gain your trust to get you to talk. There is almost never anything to be gained by you speaking to the police at the time of your arrest. And absolutely never, ever waive your right to speak to counsel because you may believe, look, I'm going to look guilty if I don't answer questions. Again, it's the wrong way to look at it. Never waive your right to speak to counsel. And it's really only on the rarest of occasions, for the reasons, let's say, of an alibi, where you would want to speak to police. But again, only do that after you speak to a lawyer that you trust. So bottom line, in our system of justice, it's the trier of fact, and it's either a judge or a jury. They're never allowed to make any inference from you exercising your right to remain silent. And if they do make an inference or any type of conclusion about you exercising your right to remain silent, then the charges against you may get withdrawn and you walk away as if nothing ever happened. So if you like this video, please subscribe so you can see more videos from our law firm.